My lords, my lady, in terms of housekeeping, if I can take a moment on that, I apprehend, obviously, there are a couple of questions which are left over from this morning's session. Having discussed with my learned friends, we're confident by the time that we all finish, we will have addressed between us all the points. What I propose to do, given the time, is to deal with the primary and secondary obligations point, if I can use that shorthand, and also my Lord Briggs's preprandial point.
My
preprandial point.
Oh, yes.
Yes.
I hope you might get a label for that.
The responses to, I said there were 7 critiques of our case. The responses to the other critiques, which I won't have covered, to the extent that they require an individual answer, because some of these points essentially overlap, they'll be picked up by what my learned friends say. All of that may take us a little later than 3:15, but of course any time we use this afternoon we won't have full reply tomorrow, but I hope the court will indulge us if needed for a few minutes. My lords, my lady, let me therefore say a few words about the accountor's primary obligation point, which of course it's not at the heart of our appeal, but of course is a relevant point when we're considering what is the nature of an account of profits. So let me try to set out our position on it. Now, it's important to note, as a matter of classification, we submit, that there are several different things that might be referred to, and sometimes are referred to in the case law, when one uses the phrase account. And the same word can be used in different contexts in the case law. And that means that sometimes the case law, if I may say respectfully, doesn't always focus on the particular usage of the word that's being adopted at any particular moment. First, as I said this morning, it's of course right to say that there is a primary obligation to account for trust assets, which is owed by trustees in relation to the property entrusted to them. One might call that the common account. In certain circumstances, it might also be owed by fiduciaries when they are custodians or they have custody of the principal's property. A beneficiary can seek an account from a trustee at any time, quite independently of whether there has or may have been a breach of any duty or wrongdoing, or indeed any event at all. Second, there is the account which arises in response to willful default, i.e. where there has been misconduct in relation to the trustees dealing with the trust assets, such, for example, as failing to invest the trust property for the benefit of the trust. Once one of those types of account has been given, the beneficiary can choose to falsify it if there's been a misapprehension of trust property or an unauthorised disbursement, i.e. the beneficiary can choose to proceed as if the property wrongly dissipated were still part of the fund and ask the trustee to make good the missing part. Alternatively, the beneficiary can choose to surcharge, for example in the case of willful default, to proceed as if the fund included the money which the trustee should have made for the trust and ask the trustee to provide that amount. The respondents were not entitled to either of those 2 types of account in this case, as we were non-custodian fiduciaries. Further, neither of those processes is itself an account of profits, although each may lead to an account of profits if discrepancies are identified when the account is taken. Third, and separately, if, as in this case, a non-custodian fiduciary breaches their duty and the principal subsequently brings a claim to enforce the duty, the principal may, if they're successful in establishing that there was a breach, elect to claim an account of profits. We would say that this is better analysed as a secondary remedy, i.e. a remedy for the breach, although I acknowledge that the contrary view is very much present in the academic literature, particularly espoused by Professors Smith and Stevens. In support of that remedy, as I'm calling it, the fiduciary may be required to give some disclosure of the profits he's earned as part of, in a no-profit case, or subsequent to, in a no-conflict case, the breach, both in order to enable the claimant to make an informed election between an account of profits and a claim for damages or equitable compensation, so-called island records disclosure, or from a case management perspective, as happened in this case, so that the court in this case was able to analyse on an informed basis, because it saw the totality of the profits, which are and which are not profits which the principal is entitled to require the fiduciary to hand over. That is not itself, we say, the account of profits, although it forms part of the overall process of taking an account of profits. The account of profits is the process by which the courts decide which profits are liable to be paid by the fiduciary to the principal. Fourth and finally, there is the payment order, which the principal can seek consequent on the taking of the account, i.e. the order giving it financial effect. And while the first obligation is an absolute one, the principal is absolutely entitled to an account from the fiduciary in relation to the property of which the fiduciary is a custodian. In the third case with which we are concerned, there may be other legal rights and defences which the court has to take into account in deciding on the availability and extent and scope of the remedy. For example, the degree of connection between the breach and the profit, which is the focus of this appeal, profit-sharing agreements and equitable allowances. Now, if what the fiduciary has done is to take money or property that belongs to the principal for himself, then it may be that the primary obligation to account may be coterminous with the court-given remedy, and it would all be very straightforward. But we submit that that doesn't mean that different processes are not going on and operating separately from each other. And the issue comes to the fore most obviously, as we've been submitting, in the case of a pure conflict breach, because before there can be any court-given account or order for payment, the court in a no-conflict case has to identify what the relevant profits are with which the account is concerned, i.e. the relevant pool. And the distinction between these various categories, as I mentioned briefly this morning, was drawn by the Singapore Court of Appeal in the UVJ case. The reference is page 3001. That in turn cites the decision of Lord Justice Millett, as he then was in the Hong Kong case of Libertarian. The reference is, I think I may have another zero. I've got 20340. I'll give the court the right reference to that. I think I've got a typo in my note. And has also been referred to by my Lord Briggs extrajudicially in the article, which is in the bundle at 3287. Now, we submit that the respondents elide some of these distinctions in suggesting that the remedy of an account of profits involves an absolute primary obligation to hand over all profits. But we submit, for the reasons I've set out, there are different processes going on and one has to keep them separate. The reference to Libertarian is 2934. I should say that we accept that our written case at our paragraph 60, second sentence, does, on reflection, overstate the position. We were focusing only on the point in issue in this appeal, so I think we have overstated the position a little. We accept, of course, as I've just said, that there is a primary obligation for a trustee and sometimes a fiduciary to provide an account to the beneficiary of the trust or principal's assets. But that's different to the remedy of an account of profits for breach of fiduciary duty, which we are concerned with here. The reference to our written case is at page 166. So I hope that's a response to a number of the points that were put this morning by my Lord Burrows, my Lord Richards.
I'm afraid I think it's a very complex response to a quite straightforward position. I mean, we're not concerned with the first types of accounts that we went into. I mean, you're quite right that they exist That's not what we're concerned with at all. And I would suggest to you that there is a duty on a fiduciary to account for the profits, if you like, for which he's accountable, which takes account of all the points you raise about the connection and so on and so forth. But that is the duty. That's not a remedy. That's an obligation of the fiduciary. And then, if necessary, but only if necessary, the court can order the taking of an account, just as it can in all sorts of cases, not just trust cases.
Yes.
As I said this morning, it may often be perfectly possible to determine the amount without taking accounts in chambers, as it were, in the ordinary way. For my part, that's the only part of the meaning of account, both as a duty and as a remedy, that is relevant to this case. I would actually just add the point that it's not just where there's a breach. It's the duty to account, it's the failure to account, which, if you like, is the breach.
Well,
I'm afraid I do take issue, I just want you to know that, yes, with the premise of what you've told us, as well as saying that I think what we're focusing on here is rather narrower than the explanation you gave.
My Lord, yes. I mean, I don't want to repeat what I've just said, and I hope I fairly noted that certainly Professor Smith and Stevens analysed the whole area in that way, in terms of primary duty. But with respect, we do submit it can be helpful to distinguish cases where what the court is doing is saying what's happened to the fund of which you were custodian, and cases where the court is saying you have made a profit. You weren't in custody of any assets at all. You've made a profit. There has been a breach of duty. What is the extent of your liability to account? But
if you think about FHR Ventures, there the fiduciary obtains a benefit through his position, namely the secret commission. He is treated in equity as holding it on behalf of his principal.
Yes.
So, and so the case decided there's a there's a property interest in the commission. It's treated as the property of the equity. In equity, it's property of the principal.
And your obligation is to disclose that you've got it, to give it to the beneficiary, and in the meantime to look after it.
Yes, in respect of, we would submit in respect of, coming back to the main point of this appeal, in respect of those profits which you would not have made even had you acted in conformity with your duty. But that gets us back into the main point.
The distinction between custodians and non-custodian fiduciaries is perhaps a bit too simple. I mean, you're treated as a custodian. I mean, the person who took the bribe, or whatever it was, in FHR is treated as a custodian of that, which is why he has to account for it to his principal.
Yeah, and I accept there's a proprietary remedy there as well, absolutely. I mean, if you paid out the money with knowledge, then you'd still be liable, because you have a proprietary obligation, which once it's fixed on your conscience, you either have to give the money, so to speak, or if you've dissipated it, you're still liable to provide it.
And how does but-for causation operate in relation to the proprietary remedy?
The but-for causation applies to identify the pool of assets to which the account applies. If there is a proprietary remedy, then it would apply to, if the but-for causation test would apply, it would apply to those assets which form part of the relevant pool, i.e. the assets in respect of which the account is taken, i.e. the assets in respect of which the fiduciary has to account by way of payment to the beneficiary. The reason why I'm hesitating about using the word account is one shouldn't forget that in this case, for case management reasons, we had to provide disclosure of a whole range of assets, including, for example, the RBS assets. Now, the RBS assets were assets which were obtained as, let me try and use neutral language, part of the story. it was held by the judge that those assets were too remote. There was no sufficient connection between the RBS monies and our position as fiduciary, applying the current test. The reason why I'm cavilling slightly about seeing the whole thing in terms of primary obligation is that on one analysis it could be said, well, those RBS assets form part of the account. They were assets which we had to disclose and show that we'd got, but they weren't assets which we had to pay over to the beneficiary.
You weren't accountable for them. They weren't a profit for which you were accountable.
That's right. Absolutely. They weren't a profit for which we were accountable, but they were on the taking of the account, so to speak,
Yes,
on the order.
The court had to decide whether or not
Precisely.
there was the sufficient connection.
Precisely. My Lord, that's all I was going to say, at the risk of being too...
Could you just give me, do you have them at hand, the references to Smith and Stevens?
Yes, I do, my Lord.
That would be just very helpful.
Oh, sorry, I said I did, and I'm not sure.
Well,
we'll provide it. It's the articles in the bundles. But my Lord,
Okay.
when we provide overnight the printout, so to speak, electronically, those things, we'll add in the references. Before I sit down and hand over to Professor Virgo, I was just going to provide an answer to my Lord Briggs's point as to what's changed. I won't call it the grandiose point, the what's changed point. And there are really, I can take this relevantly shortly because they are short points. There are really three parts of the answer. The first, as I referred to before the short adjournment, and we've set out in our written notes, there is now, compared to the 1930s, 1940s and 1950s, a massively increased incidence of fiduciary duties because fiduciary duties are found in commercial contexts where they were not previously found. In many takeover situations, merger situations, joint venture situations, contractual fiduciary duties are found and put into contracts in circumstances which we don't find in the earlier cases. Now, I can't provide a demonstration of that in sort of percentage terms, but certainly, if I may say respectfully, all members of this court will be familiar with the sort of modern contracts which on the face of it are very commercial, almost red in tooth and claw contracts, where nonetheless there are fiduciary duties imposed by contract. That is one change. The second, again as I referred to earlier, is that the dichotomy, the almost Manichean distinction between contract on the one hand and fiduciary duties on the other, has changed because one has on the contract side, a readiness to impose duties, such as duties of good faith or duties of fair dealing in the relational contract sense, which were not part of the contractual landscape when the earlier decisions were made, and therefore the continuum, if I can put it that way, between contract and fiduciary duties is a continuum rather than the completely separate worlds as they were previously. And that brings into sharper focus, in my respectful submission, the availability and centrality of causation on the one hand and its absence on the other. The third point, and this really is a freestanding point, I'm afraid it's not really an answer, if I'm frank, to my Lord's what's changed question. The third point is really this. We submit, as the court has appreciated, that as a matter of policy, there should be a causation test. That has been adopted in other common law jurisdictions, as Professor Virgo is about to explain, and that also is a relevant change, at least for this court to reconsider the question, because one would normally wish the position to be broadly the same in common law jurisdictions, unless there's a good reason for it not to be. And in circumstances where the Singapore Court of Appeal in particular, and other courts, as you'll hear, have said we're not going to go down the line of a causation route, it is appropriate for this court to consider, of course we would say, and to change, but certainly to consider and reconsider the position, especially as it was at least 60 years ago since this point was looked at. And as I said earlier, even in Regal, this particular point of causation is not with respect to the court in Regal, at the forefront of the argument, even in Regal. So, my Lords, those are three short responses to my Lord Briggs's point.
On the first one, can I perhaps ask, would it not be fair to say that the parties who've contracted for fiduciary duties must be taken to have intended those duties to have all the characteristics that the settled law imports?
One could say that, but equally, when I don't want to start giving evidence, but often when one looks at the incidence of fiduciary duties in the contractual context, especially when very complex contracts in the City of London, it's fair to say, putting it as neutrally as I can without giving evidence, that it is often very difficult to read sensibly the incidence of the fiduciary duties alongside the contractual obligations. And it may often be actually the contrary, which is the case, i.e. people have put in place an obligation which is a fiduciary obligation without realising the scope and extent of that obligation, and that it doesn't sit easily in what is essentially otherwise a contractual relationship. So,
or it may be that what used to go without saying now has to be said in the contract.
In the sense of fiduciary duties?
In the sense of how to behave towards the other person.
Well, it may not. I mean, when one says what has to go without saying, I mean, it comes back to a point I was submitting earlier, which is there is a fundamental legal distinction between the fiduciary obligation, for example, which one joint venturer owes to another, and the non-fiduciary, but nonetheless very strict obligation, much more than a normal contract, which one party in a relational contract will owe to another. Now, whether you choose to set up your contractual relations as a relational contract or a joint venture, in my respectful submission, most people will not be aware of the very stark differences in legal obligations that arise from that choice.
Yes, but most sophisticated joint venture agreements are entered into by skilled lawyers. And, you know, if the joint venture strays into the realm of partnership or some of the instances of the realm of partnership, so be it.
Yes, well, certainly some joint ventures are like that, but one can also have the joint venture where two people decide we're going to set up a fish and chip shop or something like that. I mean, the joint venture cases do range from the absolutely lawyered and expensively and extensively lawyered cases to the fairly ad hoc.
Yes, but I mean, it's the informal nature of partnership law. It takes very little to set up a partnership. If you conduct business in common with a view to profit, you can find yourself having the obligations of a partner.
Yes, but one can have the obligations of a fiduciary even absent a partnership. I mean, again,
you can do.
A lot of JVs will exclude a partnership, but there may still be fiduciary duties.
I was just going to ask you, Lord Wilson, whether there are any authorities you rely on for the proposition that one joint venturer owes a fiduciary duty to the other joint venturers. By all means, add it to the overnight document if you like, but I'd be interested to know what you rely on. I think there's one Court of Appeal case where I think Lord Justice Etherton gave a judgment, but apart from that, I'm not actually aware of any case. I'm thinking, of course, of joint venture agreements which are not partnerships.
Yes. What's running at the back of my mind, and I will check this overnight, is a decision, I think it was Justice Peter Smith in this area, but that's very much a bell ringing at the back of my mind, and I can't remember whether that decision went on appeal. But I will take that on board and come back to my Lords, either overnight or when we reply tomorrow.
I think the cases some of the things I've said that you may be referring to about joint ventures, not sure really helpful, because it was more in the other direction, that one shouldn't always think there's a clear and bright line between fiduciary duties on the one hand and a contract which is a kind of zero-sum game in the other, and there's an intermediate category of cooperative type of venture contracts where one ought to recognise duties more similar, though not identical, to the partnership situation.
Yes, that was the point which I was praying in aid as part of my answer to my Lord Briggs's point as to what's changed, so to speak. What's changed in the legal landscape is that we don't have this sharp distinction anymore, but we do have more of a continuum. Whether that's a sufficient answer to my Lord Briggs is a matter for my Lord, but that is one of the things that's changed. The 3 points I was making is the greater incidence of fiduciary duties, the relationship between fiduciary duties and contract, i.e. the continuum point, and third, the movement of other common law jurisdictions. And in an ideal world, common law jurisdictions would treat this point of principle in the same way, because it is, at the end of the day, really a point of principle. My Lords, unless there are any further questions, I was going to hand over to Professor Virgo.
Will one of your colleagues be dealing with the point I raised about authority in support of your second proposition?
Yes. We're going to deal with that, I hope, as part of our response to the points on the facts of the particular case.
I see.
Unless I can assist that.
Thank you.
Yes, thank you.
My Lords, my Lady, I plan to deal with two matters raised by the respondents. First, that the balance of academic opinion is against the recognition of a test of but-for causation when assessing account of profits. And secondly, that the reliance on overseas case law is misplaced or does not advance our case. In fact, when you look at the academic literature and the overseas cases, a number of themes emerge, and I think there are four significant ones. Significant dissatisfaction first with the strict approach adopted in England when assessing the account of profits. Secondly, widespread recognition that the profits for which the fiduciary should be accountable should be determined with reference to causation, albeit particularly in the academic literature, often without further analysis of the appropriate test of causation. Thirdly, sometimes explicit recognition that a test of but-for causation should be adopted, and true of some overseas cases, whilst the language of but-for causation is not used, the approach adopted is only explicable on that basis. And fourthly, a recognition that the remedy of account of profits should sometimes be limited either by reference to causation or by reference to remoteness. So I plan to look briefly at some of the academic literature to illustrate those points I have just made, but I will particularly focus on the overseas cases and look at a few of them in some detail. So, as regards the balance of academic opinion, first, there are a number of commentators who have been critical of the punitive nature of the account of profits remedy. I'm going to refer to two briefly. Significantly, Professor Gareth Jones, in Unjust Enrichment and the Fiduciary's Duty of Loyalty, published very soon after Boardman and Phipps was decided, but also very soon after the publication of the first edition of Goff and Jones on the law of restitution. And Gareth Jones recognised, and you'll find this at page 3174, that the result in Boardman and Phipps was penal. He did not consider the language of causation, but he did say that the fiduciary had not been unjustly enriched. Now, in our submissions, we are not focusing on the language of unjust enrichment today. The notion of unjust enrichment has moved on significantly since then. But the crucial point was that Professor Jones was very critical of Borman and Phipps in requiring the fiduciaries to disgorge their profit, even though the principal, the trust, had actually benefited from their actions. And this has been developed.
That's a point that doesn't arise at all in this case, though, isn't it?
It does not arise in this case at all, but in the Supreme Court being aware of the wider implications, and particularly Borman and Phipps relying on Regal and Gulliver, it has been subject to forceful criticism. Similarly, John Langbein in the Yale Law Journal has been very critical of the award of account of profits in cases such as Boardman and Phipps on the basis that it involves over-deterrence. Secondly,
Do you have a reference for that?
I do not have a reference to that one.
Is that a way of saying it's not in the bundle?
It is in the bundle. It is in the bundle.
I don't think it is in the bundle.
Isn't it?
I've seen it referred to, the Langbein
Right.
article.
We
but I don't
refer
think
to
it's
it
got
in our written case, but it's not in the bundle.
Well, if you could add that to your overnight tally.
We will add that to the list, certainly. Secondly, on causation, which of course has been discussed at length this morning, we acknowledge that contemporary English equity has rejected a causation test to determine which profits should be disgorged, but we argue that a causation test should be adopted. And in fact, significant numbers of commentators have acknowledged that a causation test is either inherent in the existing law or should be adopted. So, for example, Professor Matthew Conaglan, in an article which is in the bundle, published in the Cambridge Law Journal, and you will find the relevant part at pages 3101 and 3102, whilst rejecting but-for causation and the counterfactual analysis and preferring attribution analysis, does say that that involves some form of causal analysis. And significant numbers of other commentators likewise recognise that causation is inherent or should be adopted. For example, Mitchell, McFarlane and Hudson in Hayton, McFarlane and Mitchell on equity and trusts, and the relevant passage will be found at page 3483, say we prefer the view that a principal must establish a causal link between gain and the breach of duty. Again, they do not support but-for causation. They say a cause should be sufficient. Likewise, Lucina Ho argues for the recognition of causation in her thesis that the fiduciaries should be regarded as having acted loyally, and then you work out what profits they would have made. That is but for causation.
So the counterfactual is that they acted loyally.
Absolutely. And you will find that at 3410. And I will mention my Lord Briggs extrajudicial article that the relevant part can be found at 3288. And I will quote this. There are cases at one end of the scale where it was so obviously a breach of trust for the trustee to make and keep the relevant profit without full disclosure, that causation has little, if any, role to play. But there will be others where there is an identifiable profit, but it is in part derived from activities, including those of third parties, that are apparently legitimate in themselves, where isolating that part of the profit which truly is within the scope of the duty broken cannot sensibly be undertaken without some element of causation analysis. With respect...
Is that saying any more than, well, perhaps Lord Briggs can himself...
Certainly
is that saying any more than that there is a remoteness element to be taken into account?
Lord Briggs does not say what test of causation should be adopted.
Yeah, but remoteness is a criterion,
Indeed,
of course.
Absolutely, and I will come on to that.
I think I say elsewhere that there's always a danger in this sort of lecture of finding the brief on your desk the next day. In this case, it's taken about a couple of years.
Absolutely. It was an extrajudicial pronouncement.
We're just taking care not to be too dogmatic on any one position.
But arising from what Lord Briggs said there, there is, I think, an important distinction drawn. Some profits are obviously caused by the breach. So where there is misappropriation of an asset from a principal, well, clearly that profit was caused by the breach. But causation is still relevant there. There will be other cases where isolating the profit within the scope of the duty cannot sensibly be undertaken without causation analysis. And we submit that is this case.
That's Virgo. When you mentioned Professor Conaglan and his approach being one of attribution,
yes.
Do you regard, or is it your submission that attribution is a type of causal enquiry, or is it actually something different?
It is our submission that, agreeing with what Professor Conaglan said, attribution is indeed a causal inquiry. I hesitate because there are some of the recent Court of Appeal judgments where the language of attribution has been used and causation has been rejected. But Professor Conaglan argues consistent, and his approach is very much one interpreting the state of the authorities. That's why the language of attribution is used, but he acknowledges it is a causation test within it.
I think it's fair to say that there are other academics who also refer to attribution who do see it as distinct from causation. I'm thinking of Professor Stevens, for example.
Yes.
But you would just, I understand by your answer there, you would say, well, that's one way of looking at it, but your approach would be it is a form of causation.
It is a form of causation. To determine which profit should be attributed to, and we are not submitting the language of attribution should be used, but since it has been used in some cases, to determine which profit should be attributed to the breach requires a causation analysis to determine what attribution means in this context. And for completeness, there are commentators who have focused on remoteness rather than causation, picking up the point Lord Hodge has made, particularly Professor Mitchell in causation, remoteness and fiduciary gains, where at 3214 he says that claims to recover fiduciary gains may also be subject to a discretionary rule that intervening actions by the fiduciary can render some gains too remote to justify ordering her to account for them. So there is a significant amount of commentary on the remedy of account of profits which acknowledges that causation or remoteness, and I will be submitting that remoteness is part of causation, is relevant when determining the account of profits. Where the academic literature falls short is failing to then move on to provide detail as to the appropriate test of causation. And that is where the overseas cases are particularly helpful. But I will pause at that point before moving on. Are there any particular questions on the academic literature? So looking then at other jurisdictions, a number of common law jurisdictions recognise that the assessment of an account of profits should be subject to some form of causation test because they have been influenced in most cases by English authorities. I submit they are highly persuasive for this court, and they are relevant, particularly because some of them specifically adopt a but-for test of causation. Others don't, but can only be explained by reference to adopting a but-for test of causation. It is worth noting that some of these cases resulted in there being a full account of profits, but that does not mean that the but-for test was irrelevant. I am thinking in particular of the High Court of Australia case in Ancient Order of Foresters, which I will come back to in a minute. There was a full account of profits, but that it was still consistent with the but-for test being applied. It was simply a case where, without the breach, there would have been no profits. But there are some cases, some jurisdictions, where there has been explicit recognition of the but-for test of causation, particularly Singapore and Australia as well. Now, Singapore, the leading decision, we've already made submissions about this morning, is UVJ and UVH, a decision of the Singapore Court of Appeal. A case concerning the executors of an estate who had failed to distribute shares in companies in which they were also directors, and they received secret profits, remuneration and other benefits as directors. It was found that even if the executors had not voted the estate shares in support of them receiving those benefits, they would still have received them because of the affirmative votes of other shareholders. So there was
Can I just say, that wasn't really looking at a counterfactual, it was just counting up the votes.
It was indeed that, the but-for test of causation was that had they not breached their fiduciary duty, that counterfactual, they would still have received the remuneration and the benefits. So there was inherent within the but-for test a counterfactual, that the breach of fiduciary duty had no impact on the benefits they received, so those benefits did not fall within the account.
So who had voted? Was it the shareholders?
They were shareholders themselves, and they voted, but they were minority shareholders. So other shareholders voted, and it's the majority. If the minority shareholders voted...
It's analogous to what we're talking about, is it? Because the analogy would be if the executors got approval, I suppose, from the court, that they, or from the beneficiaries of the deceased's estate.
If that was the relevant counterfactual.
But isn't that the relevant counterfactual in our case?
Well, in our case...
Isn't it the authority, isn't it what the beneficiary, be it the company or the beneficiaries of the trust or whatever, would have agreed to, which is the counterfactual being advanced?
But there are other counterfactuals, and Mr. Pringle will be looking at this a bit later, that if they had resigned...
But just on this particular thing, the director, the executors who were directors received remuneration. They were allowed to keep it because the shareholders, the disinterested shareholders, a majority had voted in favour.
Yeah.
I'm just saying...
Indeed, it is certainly a different counterfactual in this case.
Right.
But it is still a decision of the Singapore Court of Appeal which adopted but for causation.
Yes.
Can you refer us to the relevant paragraphs?
Yes.
Of
So at the end of paragraph 75 at 3026, it is framed as a question, but the question is answered positively. The question before us is whether the relationship needs to be one of but-for causation. Put in another way, the question is whether the profits would have been made by the fiduciary in any event without the breach. And
so what did the breach comprise then?
I'm sorry?
What did the breach comprise?
Their breach was that they held on to the shares as executors when they should have distributed them to the rest of their family. So the shares should have been distributed to siblings before.
I'm curious.
But wouldn't then the relevant question be, if they'd done that, would the siblings still have voted for them to get the remuneration and the benefits? Isn't that the right counterfactual?
Well, the counterfactual here was that on those facts, the votes of the majority, bearing in mind, even if those shares had gone to the siblings, they would still have been minority shareholders. So it was
They wouldn't then have been executors owing any duties to the beneficiaries.
No, they wouldn't, but they had as
I feel that the
executors...
consent here has come from the wrong party to be analogous to our case.
Indeed, and it is not my submission, this is analogous. It is, however, a decision where the but-for test was explicitly adopted.
I know, but and the court decided that the but-for test should be applied, and
yes.
I mean, I'm puzzled by the decision. I shall obviously have to read it, but yeah.
I will refer your lordships, your ladyship, to paragraph 88 at page 3035, where there is an explicit adoption of the relevance of counterfactual analysis. Now, the respondents in their written case seek to dismiss our reference to this decision of the Singapore Court of Appeal on the basis that the court declined to make a finding as to where the burden of proof would lie. And they do indeed decline to make such a finding at paragraph 98, which is at 3039. But that is a matter of application of the test and doesn't undermine the test itself, which is a test of but-for causation. Secondly, in Australia...
So for your purposes, that actually is a subsidiary question which could go either way, as to where the burden of proof lies.
It could go either way, but as Lord Wolfson said this morning, we are content to submit that the burden should lie on the defendant. But in our written case, we do consider implications of that burden of proof going either way.
It was heavily dependent, interestingly, on an English decision in Re G. I'm looking at paragraph 90.
Yes.
Can't help wondering whether that was really a but-for case either. There we are.
Were the, in this case, were the executors directors by dint of being executors?
No, they were voted to be.
Or were they directors anyway?
My recollection is they were directors already.
That is quite a significant difference, isn't it? Because they haven't become directors by virtue of their fiduciary position as executors. That's perhaps the distinguishing point.
Yes.
And the case was concerned with directors' remuneration, was it?
Yes.
Yes.
And whether that remuneration fell within the scope of their responsibility as executors, and whether therefore it was caused by the breach of duty.
Yes, I mean, they were already directors.
Yeah.
It's hard to see what the necessary connection or nexus is.
Yeah.
Which is the result in the case, albeit using but-for causation.
Yeah, okay.
I will be much more quick in my reference to Ancient Order of Foresters, a decision of the High Court of Australia. We consider this in our written case. This is a decision on knowing assistance, but in the course of analysis, the justices, 4 of them, adopt the but-for test of causation, both for liability for knowing assistance and for liability for breach of fiduciary duty. And they regard there being no difference between the tests. You can find that at paragraph 13 at page 2506 and paragraph 80 at page 2526. And the references to but-for test of causation can be found at paragraph 9 on page 2504 for Chief Justice Kiefel and Justices Keane and Edelman, and at paragraph 88 at Gagala J at page 2529. In their written case, the respondents say that the majority did not establish a but-for test involving hypotheticals in that case. This was a case involving dishonestly assisting in taking clients and confidential information from the fiduciary's principal, and there was also preparatory work whilst the fiduciary was still employed by the principal.
Can I just take you to paragraph 9 at page 2504? Because I have read this a few times and it wasn't clear to me that they were actually adopting a but-for test, because they go on. I mean, it is true that it's said it is sufficient to show that the profit would not have been made but for dishonest wrongdoing. That isn't the same as we always apply a but-for test. It seemed to me that in the rest of the paragraph they go on to show actually these are exceptions. There are exceptions to the but-for test. Am I missing something?
They do go on to accept that the counterfactual, and they acknowledge there can be counterfactual analysis, but you cannot assume honesty where there is dishonesty.
Right.
So they focus on the nature of the counterfactual analysis.
So the counterfactual, if there was dishonesty, in the real world, then in the counterfactual world you have to assume they're also dishonest?
So, indeed, but the real focus on the counterfactual, there was no detailed analysis of a hypothetical counterfactual, simply because this was a case where the assisters would not have obtained any profit had they not assisted. Everything turned on the assistants. So, but for the assistants, they would not have made a profit.
It's interesting to note in the same paragraph, the judges rely upon the Gray and New Algerita Porcupine Mines case, Lord Radcliffe's famous dictum in the Privy Council.
Indeed.
Looking at the paragraph as a whole, it's looking as if they're dealing with a case that a much more stringent test of causation had to be applied, some kind of effective cause test, and saying, no, it doesn't. And as it were, falling back on but for as a sufficient element for the purposes of that case, rather than treating but for as a sort of standard test to be applied across the board by way of a defence available to fiduciaries.
Yes.
And they're really doing the exact opposite.
Well, they are acknowledging that the question to ask is, but for the assistance, would the profit have been made? And of course, what is significant is that they align the test for assistance with that of breach of fiduciary duty, which is not what the state of law is in England at this time. Other countries recognise a test of causation but do not necessarily make reference to but for causation. So I will refer your lordships and your ladyship to the decision of the Supreme Court of Canada in Strother, and there are various references within that decision to causation. The majority at paragraph 79, page 2857, recognise that a fiduciary is only liable to account for profits which were caused by a breach of duty. This was actually a case where the profits were limited. The account was limited, and I will come back to that with reference to some other decisions as well.
It's paragraph 79, did you say?
Paragraph 79, 2857.
Yes. Can I just be clear about the submissions generally? Because I think we've already established that it's not good enough for you to establish that a causation test should be satisfied. So if I was to say, further on from our previous exchange, well, let's assume there's a contribution. The fiduciary position the profits must have been contributed by or come from or out of the position as being a fiduciary. One might say that's establishing a causal test, but it won't give you what you want in this case, because you have to go to a but-for causation test. So in a sense, showing us cases where a causation test has been accepted, but not a but-for causation test doesn't help you, does it?
Well,
am I wrong?
It helps only insofar as the state of English law is there is no test of causation. That is what the English authorities say. And we are, in this jurisdiction, out of line with what is happening in Singapore, Australia, and Canada.
But I think you would already accept that you might well counter what's being said, there is no causation test, by saying, well, actually, they are really applying a causation test. It's just not a but-for causation test.
And then the question is, what is that test of causation? And it is our submission that it should be a but-for test.
And by but-for test, you mean you should be able, or the fiduciary should be able to show, even if I hadn't breached my duty, I would still have made all this profit or some of the profit, so I should keep that.
Yes, yes.
That's what you need to show is the test of causation for this case.
That is indeed what we need to show.
The ancient order case seemed to say that but-for causation will be sufficient. It doesn't say you have to show but-for causation. It says it would be enough if you did, and it then goes on to mention a whole string of examples when you don't have to show but-for.
Right.
So is there anything better than that in the Australian authority, or is that the high point?
There are other authorities. That is the most recent Australian authority. There is one other one that was, my Lord Briggs mentioned earlier, that I will go to now, and that is the decision of the High Court of Australia in Warman and Dwyer. This is a case where there is no explicit reference to but-for causation, but a counterfactual analysis is adopted. So it is our submission that this is consistent with a but-for causation counterfactual analysis. This was a decision involving an appropriation of a business opportunity by a manager in the claimant company. There was a clear breach of fiduciary duty because the manager used his knowledge and position as a senior executive officer to advance his own interests by reducing the other party's confidence in his employer, so that the other party then terminated its agency with the employer earlier than it would otherwise have done. And at page 560, which is at 2687, the High Court of Australia found that the fiduciary was actively dishonest and he had obtained an identifiable profit from that dishonesty. But the account was still limited to 2 years of profits, and that was actually reduced from the 4 years of profits which had been awarded at trial. And it is our submission that that is consistent with a...
From this particular client, was it?
So the profits that the manager made from working with this other company to develop the business opportunity by taking clients and information away from his employer.
Could you give me the page number again, please?
Yes, that is page 2688.
Thank you.
At page 500 for the reference to active dishonesty, that was page 2687. But at 2688, there's an extended analysis of the approach to determining the account of profits, including the following. It may be said that the relevant proportion of the increased profits is not the product or consequence of the plaintiff's property, but the product of the fiduciary's skill, efforts, property, and resources. The stringent rule requiring a fiduciary to account for profits can be carried to extremes, and in cases outside the realm of specific assets, the liability of the fiduciary should not be transformed into a vehicle for the unjust enrichment of the plaintiff. And crucially, at page 567, which you will find at
Just before we go there,
Yes.
at the foot of this page, they say it's for the defendant to establish that it's inequitable to order an account of the entire profits. So that seems to be the test.
that it be inequitable. As I say, my lord, there was no express reference to a test of but-for causation.
But isn't the underlying assumption that all the profits were caused in a but-for sense? But it's a question then of cutting down what's awarded to take account of the fact there was another contributing factor as well.
Indeed.
But if you look at the top of 2689, it all ultimately devolves into an equitable allowance, doesn't it?
That's what I was about to say. Yeah.
Well, an equitable allowance in the sense only of valuing the fiduciary's skill and efforts is what an equitable allowance is. That is not what happened in this decision. The decision to reduce the account by 2 years was for two reasons. First, and at page 567, 2694 in your bundle, it was found that if it were not for the breach of fiduciary duty, the principal's distributorship business would only have continued for 1 more year. And it was also found that the fiduciary had acquired experience, contacts, know-how and services of the principal's employees, such that but for the breach, it would have taken the defendant a further year to establish the business. In other words, this is a decision where the pool of the profits that had been made were reduced significantly by reference to a counterfactual analysis. What would have happened had the distributorship, had there not been a breach of fiduciary duty? The distributorship for the principal would only have lasted 1 year, and there were other benefits which were considered to be beneficial for 1 further year. Now, this might be analysed in terms of remoteness, adopting remoteness to limit the account.
Isn't this then bumping up against that other public policy imperative, which is that people should be allowed to move employers and take their skills and know-how with them, and not be stopped and kept with one company, and that's a balance that you come across when restrictive covenants are being enforced. Is that why that's the distinction that they're making here, is between the anybody's ability should be allowed to move to a different company to work and take, of course, inevitably you take with you what you've learned and your contacts, because you can't expunge them from your brain, but that's different from taking a specific opportunity.
Indeed, and it is our submission that it is perfectly legitimate to take that know-how, that experience, and resign in order to benefit from another opportunity. But I emphasise that in this case, there was a finding of dishonesty. And that was the breach of fiduciary duty.
But in this case, at the bottom of 2694, when they alight on 2 years, they present it as being because a 4-year period went beyond what was fair and equitable in the circumstances. Yeah. So they may have had some but-for analysis in their reasoning, but ultimately they're applying a test of what is equitable in the circumstances. That seems to be, you can see what I mean at the bottom.
Indeed.
Of the page.
And Lord Hodge, of course, we are in the area of equity. We are in the area of a discretionary equitable remedy, and it is important that the courts fashion the remedy to secure equity and justice. But crucially, the way the High Court did that in this case was by careful analysis of the facts to determine that the profits that had been made, so 4 years of profits, not all of them fell within the account.
Yes, because they may well have been too remote, having regard to the various circumstances they're taken into account.
Indeed, and it is our submission that remoteness, it forms a very significant factor in the fashioning of the account, and remoteness forms part of the causation analysis. It identifies the outer reach of that causation. Conscious of time, I will briefly refer to two other decisions. One of the Hong Kong court, Cao Lian Yip and Ku Hai Yan Donald, which is another case involving, it was a case involving diversion of a business opportunity where account of profits was limited for a 1-year period. Again, we submit that involves a causation analysis. A relevant dictum can be found at paragraph 133, which is at 2926, where there is a reference to the causal link. But also,
it's a paragraph?
Paragraph 133. And paragraph 139 at page 2927, Justice Marr says the duty to account is not completely open-ended. There must be some reasonable limits to it. And finally, the Strother case again in Canada, the Supreme Court of Canada also adopted a limit to the account. So it is our submission...
What's the reference for that?
So the Strother case can be found, there is a useful analysis at paragraph 95, which is at 2863. The reason for the limiting of the account in that case was that the fiduciary was considered to have severed their link with the principal, and the conflict between profit and duty was interest and duty was considered to have been spent after 15 months. It is our submission that these decisions from common law jurisdictions identify causation. Some of them explicitly identify but for causation, and others adopt a remoteness test to identify the outer limits of causation. And our submission is that these are persuasive in their analysis as to an approach which should be adopted in this jurisdiction. That closes my submissions on those points, unless I can be of any further assistance.
I think my only question is whether anything in the Yip case, Cowley and Yip, indicates the use of a counterfactual approach. True it is they talk about a causal link being required, but in the same paragraph they say they're following Regal, Hastings and Gulliver and Phipps and Boardman.
They do, and this was a case involving a diversion of a business opportunity where the breach involved preparatory steps whilst the fiduciary was a fiduciary, but it concerned
what I mean
law
is
firms.
They look quite carefully, for example, at 134, I think, at what the principal might have made if there hadn't been a breach. In other words, a counterfactual, which is a different counterfactual. They say that's irrelevant. I'm asking whether they actually do any kind of counterfactual test on what the fiduciary might have done otherwise than as a result of a breach.
So at paragraph 158,
thank you.
And I don't have a page number for that.
You can find it.
At page 2931,
yep,
there was an explicit reference to causation in determining that. Now, in terms of counterfactual analysis, on the basis that they considered that at that point the conflict had been spent, they didn't adopt an explicit counterfactual analysis.
No, I agree.
Yes, because they treated what he'd obtained was a head start, and that expired after a year.
And therefore, the causative effects of that head start, of that head start advantage arising from the breach, did finish at some point. They determined that that was after 1 year.
Yes.
And therefore, all profits arising thereafter were not caused by the breach of duty.
So inherent in that is a counterfactual where he left, set up the business without being in breach, but it took him a year to get it off the ground.
Indeed. Although they did not analyse it specifically with reference to a counterfactual, but there is a counterfactual analysis inherent within their treatment.
But even in our case, we've got the first instance judge upheld by the Court of Appeal applying what you might call a remoteness approach because they rule out some further profit. There's too indirect, I assume.
Indeed. So remoteness is there. These authorities show that when you are looking at the profits from the start and moving out, you should be looking at all those profits, not that involved remoteness involving a different transaction. If I can be of no further assistance.
No, thank you very much indeed. Yes, Mr. Pringle.
My Lords, my Lady, good afternoon. Lord Wolfson identified in his submissions two broad categories of point with which I might be able to help the court, namely first, what was and was not found by the judge on the facts on phase 1, and secondly, how our proposed but-for causation test would apply on the facts of this case. And I'm going to, given the time, to take this quickly, and where necessary I may have to do it by giving you the references so that you can look at the points later.
Yes, I understand, otherwise you're at risk of using up all your reply time.
Well, my learned friends have left me with a lot of points to deal with in a short amount of time. As for the former point, what was found in phase 1, as Lord Wolfson said, we're content for our positive case, as it were, to rely upon the way in which the findings were put in the key respects, particularly as regards the nature of the breach by the Court of Appeal's judgment. But I want to pick up a couple of points of detail and questions to us raised by the court this morning. And the first one goes to what the nature of the breach was that was found. If I can ask my Lord and my Lady to look at page 395 in the bundle, behind tab 7. These few paragraphs are where Her Ladyship summarises her findings, having gone at some length through the facts to ascertain what, in fact, the defendants did and did not do. At paragraph 422, you'll see that she considers, because this was Malone & Friend's primary case, i.e. that the business opportunity had been diverted, She says whether this amounts to an active diversion in the sense of being causative of the decision to pursue the recovery services may be questionable. I do not consider that I need to reach a conclusion on this issue, which, as Mr McQuato QC agreed in closing, essentially an add-on to his case. However, there's no doubt in my mind that in the context of fiduciary duties owed, these actions amounted to disloyalty. And at paragraph 424, she then goes on to say what the breach was that she did find. So she had said she didn't need to reach a finding on diversion because she didn't need to in order to deal with what she considered was the binary issue before her, i.e. whether the defendants were liable for breach of duty. Instead, she found at 424 that the breach consisted of what was in essence a bad faith resignation. There was certainly a resignation with intention to compete, but the necessary element of disloyalty to give it a liability in respect of acts done post-resignation is provided by the preparatory steps which the defendants took before their resignation and the disloyalty involved in their failing, while notionally acting for SCPI, to support the entities to whom they owe duties and actively aligning themselves with the family and away from their companies at the key point. And the reason why Her Ladyship couched the breach in those terms was because there had been an extensively, and I should say I'm making these submissions in response to Lord Hodges' question earlier on as to whether, and I'll come to it in a minute, as to whether we have authority for the second of Lord Wolfson's propositions. Because the legal parameters for the argument which led to this decision were based upon a line of authorities considering the question where a fiduciary or a director of a company has subsequently, after resigning from a company, exploited a business opportunity which he learnt about and which was maturing when he was in office. And you'll see, I'd ask your lordships and my lady to look at the whole of paragraphs 52 to 84 of the judgment, where that legal analysis set out, not now of course. But if I can ask you to look at paragraphs 74 and 76 specifically, and the authorities that are referred to therein, and Lord Wolfson alluded to this earlier on, that's at page 316. And if I can ask you to read the quote there from CMS Dolphin.
72?
74, sorry.
I think you said 72 and 74.
I said 74 and 76, which is over the page. 74 and 75, sorry, which is over the page. So it's CMS Dolphin, and then the way in which that is interpreted in Foster Bryant.
Yes, the opening sentences of 72, I think were consistent with what Mr. Justice Ma said in the Hong Kong case, that where it says, in order to prevent the emasculation of fiduciary duties, a fiduciary may be found to have breached fiduciary duties by reference to what he does later. Resignation will not avoid liability where the fiduciary uses for their own benefit property or information which they acquired while a fiduciary.
Now, Lord, yes, and this is where we come back to your Lordship's point. Your Lordship mentioned two things earlier. One was confidential information and the other was property.
Well, I didn't mention confidential, but there was mention.
There was mention of those two things.
Yes.
Now, I showed your Lordships the breach in this case at 424, and that is the breach that was found, and there's no appeal from it. And this appeal is concerned with the scope of the account of profits which was found in phase 2 of this case, and phase 1 was dealing with liability. Another breach which might have been found was that they used confidential information belonging to the company and there might have been an account of profits relating to their use of that confidential information. That isn't the breach that was found in this case, and it wasn't the account that was taken. The other thing that was mentioned was property of the company in the form of a business opportunity. And when it comes to that, you'll see that at paragraph 75,
sorry, I'm not focusing particularly on the breach in this case. The proposition 2 was stated very generally.
Yes.
And are you saying it is confined to information that is confidential rather than information which the fiduciary received by virtue of his office, even if it wasn't confidential as such?
Putting breach of confidence, as it were, to one side.
Yes.
The point in Foster Bryant and in the cases in the section to which I've just referred you was whether it is sufficient for the fiduciary to be liable that he has resigned from office with the intention to exploit a business opportunity of the company. Now that is in these cases a business opportunity which he has learnt about while in office. Mm-hmm. And it's a business opportunity which he subsequently exploits. And what the court says is that that's not sufficient. What you need is also to have done something in breach of duty whilst in office. And so if it were the rule in the context of maturing business opportunities, if it were the rule that simply finding out about an opportunity whilst in office and subsequently exploiting it were a breach of fiduciary duty for which you had to account, then there would be nothing in these cases. In this specific context of maturing business opportunities and exploitation after resignation, that is found in my submission not to be enough. And so the authority which we rely upon in answer to your Lordship's question is Foster Bryant.
Do we have that in the bundle?
You don't, other than the quote from it that's here in Her Ladyship's judgment. We can certainly have it added if that would be helpful.
So what do you say is the missing ingredient here, which means that this was not a diversion of a business opportunity case? Or
Because they didn't do anything whilst in office which caused the business opportunity to go to them.
Well, I think
that's what Her Ladyship wasn't willing to find.
Well, there wasn't a finding of causation, but certainly in Her Ladyship's summary of in her second judgment at paragraph 393, which is the key bundle,
yes.
Key documents bundle at 477, yes. She says that they encouraged and colluded the family to be disenchanted with their principal,
yes.
And allowed the family to know that they were an alternative. So one might say, using the language of tort, that they made a material contribution towards the divergence of the business.
Well, I was about to come to that.
I accept that there's no finding of causation. But do you take issue with anything that Her Ladyship says in 393?
Lord, no, I was about to come to that because that was your Lordship's second shopping list item for me this morning.
Yes.
And the answer is no, we don't take any issue with what's said there. And by issue, I assume your Lordship means, do we say that Her Ladyship was wrongly recording in Phase 2 her Phase 1 judgment? No, we don't.
You don't.
But that passage, respectfully, my Lord, is concerned with the question which it's common ground between both sides in this case. One isn't allowed to consider in the question of, in the context of an account of profits, namely whether the principal could have got the opportunity. What Her Ladyship was there considering was whether we caused Mr. Jaffe not to be able to pursue the opportunity. The question in my submission is whether, and in our submission in this case, is whether the defendants would have made the profits which they did, but for their breach of duty. And that is an entirely separate factual investigation from the question whether Mr. Jaffe could have made them himself.
Yes, but it seems to me that what she's doing there in paragraph 393 is explaining that while she wasn't holding that there was active positive causation, nevertheless there were these elements which were productive of divergence of an opportunity, even if it didn't amount to a finding of causation.
Well, that's an important point, Lord, because she was required to find on the facts whether or not there was a diversion first. Well, she was required to find whether there was a breach, but the breach primarily contended for was diversion, and she was not willing to go as far as that. She wasn't willing to say that the acts that we carried out caused us to receive the profits, the business opportunity, or therefore the profits that she did. What she found was that our acts caused Mr. Jaffe not to be able to pursue it, and there's an important difference. Nor is it, Lord, two sides of the same coin, because in fact, despite doing what Her Ladyship says here, it took another 18 months of negotiation with the family for them to eventually get the contract.
Yes, well, we've read the facts, and the widow seems to have been a difficult person to negotiate with.
Yes, I think that might be accepted by everyone.
That's an understatement.
The second point, sorry, and the other point from this morning that I was going to pick up as to what was found was whether there was this was, I think, my Lady Rose's point, but also picked up by my Lord Hodge and my Lord Richards, about whether there were findings, to what extent there were findings of dishonesty and deliberate breach, if we needed them on whatever the test is that ultimately came to be applied. And I don't think I can go too much further than Lord Wolfson did on that point. As you saw from the Court of Appeal's judgment, they were found not to... There was no finding of dishonesty. There was a finding of disloyalty, because that was inherent in the breach that was found. There was a dispute as to whether they disputed that they were in the positions or situations or had the degree of control within the relevant entities that would have given rise to the fiduciary duties. So, for example, there was a dispute as to whether Mr. Alexiev was an employee of the company. There was a dispute about whether Mr. Rukhadze's consultancy agreement was such as to give rise to fiduciary duties. There was a dispute about whether Mr. Rukhadze had resigned as a director of SCPI, and so on. So there was a dispute as to whether they were fiduciaries and therefore owed the duties, but there was no issue or finding about whether they knew they were fiduciaries or about whether they deliberately and knowingly breached their duties.
Bad faith resignation seems to have a connotation of deliberation about it.
In the abstract, as it were, I agree with...
But it's a sort of label which the judge has extracted from the cases which you showed.
Exactly right, my Lord, yes. It's a moniker that Her Ladyship used to describe the things which are in the case law, and as you say, I think it emanates from the case law. But when one looks at... So I accept that it has that connotation, but when one looks at the contents of the package, as it were, it doesn't involve more, in my submission, than disloyalty. Moving on then, if I may, to applying the but-for causation test in the present case. As the Court knows, our primary position is that this Court is able, if it were minded to change the test, to apply the hypothetical, or consider the hypothetical itself, based on the facts already found in the Phase 1 and Phase 2 judgments. And alternatively, if and to the extent that the Court didn't feel able to do that, we say that the matter or some of it should be remitted. And again, I just wanted to pick up the detail of that and address a couple of points that the Court raised this morning. Just dealing with one procedural point which the claimants raised first in their written case. They say at paragraph 84.2, page 227, that it's now, quote, too late to reopen the evidential inquiry, because as we understand the point, we should have asked the judge at first instance to make provisional findings on these hypothetical points in order to set up this appeal. That would, in our submission, have been a disproportionate thing to do and extremely unlikely to have been entertained by the judge, given the number of issues already before her. There are, of course, cases where one says to the Court, we want you to make rulings on all 4 of our points, because even if you're against us on point 1, because we might ultimately succeed on our appeal against the point 1 decision. It's quite another thing in my submission to ask the first instance judge to carry out an extensive factual inquiry on the basis that there may or may not be a successful appeal to the Supreme Court on a point of law which can't even be advanced at first instance.
But were you saying at first instance that you reserved your position to argue that actually there should be a but-for causation?
Yes, we did.
But you didn't ask her to make the findings that you now say she should have made in order to enable that to be applied, if that was what happened?
No, we didn't, my lady. And as I've said, we submit that it would have been disproportionate and not well received to do so in circumstances where, as I say, that it would have required authority, a court higher than the Court of Appeal to change the law. And we note in Murad, for example, at paragraph 47, that's page 1931, Lady Arden said that a distinguishing feature of that case was that the hypothetical issues which would be relevant if the judge's conclusion on fiduciary duty were reversed on appeal, i.e. if a but-for causation test were applied, had already been considered by the court because there had been a tort claim in parallel, the suggestion being, by reference to it being a distinguishing feature, that was otherwise not something that would have been expected to have happened. Similarly, at 162, Lord Clark said in his dissenting judgment that he specifically thought the case should be remitted for Mr al-Sarraj to attempt to persuade the court that it would be inequitable not to allow him a share of the profits. Again, it's difficult to see why that issue would have been remitted unless it was envisaged that it would involve further factual investigation. So that's the procedural point. Dealing very quickly with how we say the test would apply to the facts. As I think Lord Wolfson said to my lady earlier, what one would do in order to frame the counterfactual is to take the timeline back to a point before any of the things that were said to have amounted to a breach had happened. And that point, we say, is sometime around mid to late 2010, because the earliest we can see that in the judgment the preparatory steps started was autumn 2010. Now, at that point in the story, the situation was that Mr Rukhadze had put forward Mr Jaffe's, i.e. SCPI's, second and final proposal to the family as to the terms on which SCPI was willing to carry out the project, and the family had rejected it. And the judge found that that was the closest that SCPI ever got to a deal, and that immediately after that, Mr Jaffe and Mr Rukhadze had seismically fallen out. So one then reruns the timeline, as it were, on the hypothetical basis that the defendants had, as it were, a judge over their shoulder telling them what they could and couldn't do compliant with the law. And we say that what would have happened is that if they had asked the judge on their shoulder, or if they had sought guidance from the court, they would have been told, because it is, we submit the case according to the law, specifically the law that I just showed the court, that so long as they didn't act disloyally or take illegitimate preparatory steps, they were permitted to resign and pursue the opportunity on their own. If they had done that, we say they would have earned 100 or nearly 100% of the profits which they in fact earned. The reason, very briefly, why we say they would have earned those profits is that, as you can see from the events which in fact happened, they were willing to bend to the will of the family as to the terms of the contract in a way that Mr Jaffe was not. The deal which they eventually did was, the court found, a far less beneficial deal to the provider of the services than the one that Mr Jaffe had been insisting on. She said that the defendant's deal was the bird in the hand, and Mr Jaffe's more ambitious deal, the birds in the bush. And one can see her comparison of the two deals at paragraphs 118 to 121 of the Phase 2 judgment at page 189 to 190. The reason I said 100% or nearly 100% is that it might, and this is the point that one saw alluded to in the Cowley-Yip case that Professor Virgo mentioned, is that it might be that it would have taken the defendant slightly longer to set up the business than it in fact did in reality, having not in the counterfactual taken the preparatory steps that they did. i.e. it would be an analysis akin to the springboard doctrine in intellectual property cases. And learned friends say in their skeleton that doesn't involve a but-for causation analysis, but in our submission it does. The point is that but for the breach, it would have taken them longer because they hadn't, as it were, laid the groundwork. Alternatively, what I've said to what I've said already, they might have entered into some sort of deal with Mr. Jaffe. They wouldn't, on this hypothesis, have had any legal obligation to do so, but they may have been minded to do so either out of moral obligation or to draw a line under the project so that they could move forward. So what would that have looked like? Well, either a deal would have been done to give Mr. Jaffe a relatively small, I say in the context of this deal, obviously a life-changing by any other metric, lump sum payoff or exit fee before leaving of the sort that was under negotiation in the real world. In fact, what was under negotiation was that such fee would be paid by the family. So if that were the hypothesis, it would actually be a loss rather than to Mr. Jaffe rather than a profit to the defendants. Alternatively, if they had been minded to stay with Mr. Jaffe, if they could otherwise have resolved the differences between them and between him and the family, they might have said to him, well, we could just leave and pursue this on our own, but if we stay, you're going to have to soften your approach to the family, and you're going to have to perfect our 50-50 profit-sharing agreement. And if they had done that, then the profits would have been shared 50-50. So that is the worst that we say could have happened for them on the counterfactual. And the minimum effect of the test would be to cut the account in half. Just dealing very, very quickly with some points raised by my learned friends in response to that hypothetical. In paragraph 93 at page 233, they say that to have regard to the counterfactual would create uncertainty because the 50-50 agreement was found by the Court of Appeal to be too uncertain to be enforceable. But that, i.e. whether the deal was the issue before the Court of Appeal was whether the agreement was currently binding so as to limit the account in that way. That, i.e. whether the deal was enforceable in the real world, is a different point from the issue whether in the hypothetical world they would have gone on to formalise the agreement which they'd made in principle but not yet formalised, as Her Ladyship found, in which case it would have been certain, enforceable and binding. Finally, at paragraph 95.2, page 235, the claimants say that if the defendants had performed loyally, they would have earned all of the profits for SCPI and none for themselves. That, in our submission, simply ignores Her Ladyship's finding as to what would have happened in the counterfactual, i.e. that a 50-50 deal, as she found, would have been entered into between the defendants and the claimants, such that the defendants would still have received 50% of the profits, even if acting loyally. And so unless I can help the court further, those are my points, and indeed I think our points in support of the appeal. And we will get you the points, the written documents overnight and authorities that we said. Is it best if I send those to the clerk for the...
If you send them to the court registry, that's best.
Yes.
Thank you. Well, thank you very much, Mr. Pringle. Yes, Mr. Crowe.
May it please the court, our headline points, so to speak, are that the current law is well established, clear, appropriately flexible, founded on principle, and a realistic view of human nature, and on practical considerations, and there is no material before this court to suggest that its application is causing any difficulties in practice. You are the Supreme Court, so you could change the law. But there is no good reason for doing so, particularly in circumstances where the change that is being proposed, albeit in one sense a narrow point, would, on analysis, involve, first of all, a fundamental alteration to the concept of the remedy of an account of profits, and secondly, in practice, would generate considerable uncertainty where currently there is none. And in our submission, the proposal put in front of you from the other side would serve principally to increase uncertainty and hence litigation. We were going to make two relatively brief introductory points about the nature of the appellant's arguments. As you may recall, if you started your reading with the grounds of appeal, there was initially a bit of a pretense that they were asking the law to be reinterpreted. By the time we get halfway through the case, they acknowledge they are asking for a change, and by the time we get to paragraph 72 of their case, they acknowledge that it is a significant change, as Malone Friend did on his feet. It is a significant change in the law, and we will explore exactly why that label is entirely correct. As I say, the court clearly is supreme and it could change the law, but where case law has been consistently applied for a very significant number of years, and where the changes that are proposed would be radical, and there would be inevitably unintended consequences, as well as the creation of uncertainties, essentially we do submit, and simply the range of possible alternative options that Malone and Friends have been floating in front of you demonstrates that what they are really asking is a form of legislation. Now, Malone and Friends' answer to that is, oh, well, this is an area of the law that has so far always been covered by case law, not by legislation. But that isn't, with the greatest respect, an answer at all. It is the nature of the change to the law which would be legislative, in the sense that, from a cold start, Malone and Friends are asking you to abandon long-established case law in multiple ways, albeit mushrooming out from the narrow point that is the core of the appeal. And I'll develop all those in a moment. In terms of the itinerary, what we were proposing to do was to track our written case, just to give some structure to what we're saying, and obviously to develop points, answer points, as we go along. So if it would be convenient, we would invite you to have that in front of you, which is in, I don't know if you have it in hard copy, it's at tab 6 of the core bundle, page 188 of the electronic bundle. And we just point out, picking it up at paragraph 3, we just point out the obvious framework within which the debate is being conducted. As I think is common ground, this is not a discussion about whether fiduciary duties should arise, nor is it a debate about whether a liability to account should in principle be available. The framework of the entire appeal must be conducted on the basis that fiduciary duties were owed, were broken, and a liability to account for profits has been triggered, and the only debate we're having is as to the scope of that remedy. The second point we make in paragraph 4 is in relation to the commercial context, which Malone Friend dealt with a little bit after lunch, and we just wanted to respond to a couple of the points that have been made in that case. His first point, which is made both in his case and orally, is to say that the incidence of fiduciary relationships has expanded significantly since the early case law. If you want the reference in their case, it's paragraph 42. Our responses to that are, first, the fact that the incidence of fiduciary relationships may have expanded is absolutely no reason in and of itself to conclude that the legal significance of the relationship should be diluted. And we simply mention, because it is partly in response to a question my Lord Briggs asked, we mention in our case at paragraph 27, just to jump forward, but it fits here. Paragraph 27 is on page 199, which actually is in the context of deterrence. But we say at the very bottom of page 199, it may or may not be overstating things to suggest that it is that deterrence is the sole rationale, but it certainly performs an important function. There's no obvious sign that the need for such deterrence has diminished since the 18th century. If anything, concerns about business morality has never been greater than it is now, and that any relaxation of the rule against unauthorised profit would undermine the trust in trust in the commercial world. And we footnote there, I'm not going to take you to them, but we have just chosen 3 cases spaced out by about 40 years or so, 30 or 40 years, which make that point. One might have been forgiven for thinking that part of the sort of the thrust of my learned friend, certainly his written case, less so his oral case, was that these rules about fiduciaries accounting were developed in the context of formal trusts some considerable time ago. Our response is that these cases, and I think all the cases we have looked at, have been decided in the commercial context, and there have been repeated expressions of concern by the court, and those, as I say, those 3 cases footnoted in footnote 82, to the need to maintain morality in the commercial world every bit as much as in relation to formal trusts. So that would be our first response to this suggestion that there is some significance in the expansion of the incidence of fiduciary relationships. The second point in response to that is simply to observe, and indeed to some extent the defendants themselves recognise this, is that if, and this is not the point for this appeal, but if there is a risk of the application of fiduciary duties overreaching itself, then the solution would, on a case-by-case basis, the solution would lie in re-examining whether the specific relationship under scrutiny does give rise to fiduciary duties at all. Perfectly valid line of debate in many cases. May also be, again, in the commercial context, and this was touched on in some of the exchanges earlier, some commercial relationships may give rise to some aspects, but not all aspects, of fiduciary relationships. In some commercial relationships, the extent to which obligations of good faith are actually contractually expressed and therefore defined. So again, that is simply part of the context, in a sense, for responding to my learned friend's overall point that somehow this particular issue with which you are concerned needs to be revisited because there are so many more fiduciary obligations floating around now. That, in our submission, is an overstatement and essentially an irrelevance for the purposes of this appeal. The other point that is made in my learned friend's case, apart from his assertion that the incidence of fiduciary relationships has increased, the point has also been made that the context in which fiduciary relationships has arisen has also changed, to which essentially we would give many of the same answers and again emphasise that I think almost all the cases we've looked at have in fact been cases in which the law has been applied in purely commercial contexts. But the other point I just wanted to emphasise is that if one looks at, this is not a point made orally, but it is in Milan and Friends' case, and it's important to rebut it. I don't ask you to go to it, but in paragraph 42.2 of his written case, he tries justifying his argument for some sort of different attitude in the commercial world by saying that the traditional trustee-beneficiary or solicitor-client relationship is one in which there is an asymmetry of knowledge, information, and control, and that is absent from commercial relations. And we submit that that argument is wrong, and indeed, in one sense, it's sort of founded on the kind of mistake that many businessmen make in overlooking the difference between a company, which is a separate legal person, and the individuals who act on its behalf. The relevant relationship in this case is not a personal relationship between Mr. Jaffe and Mr. Rukhadze. The relevant relationship is between the individual defendants, Mr. Rukhadze, Mr. Alexiev, and Mr. Marson, and the companies which they worked for, were directors of, were employed by. The companies themselves are the entities which were owed fiduciary duties. And they were owed fiduciary duties because the individual defendants worked for them and assumed positions of responsibility in them. And they had powers to act on behalf of the company. And so, in terms of the relationship between a trustee and a beneficiary on the one hand, and a company director and the legal entity of the company itself, there is, with the greatest respect, exactly the same asymmetry of control and information. Because, and in a sense it is precisely because of the identity of the asymmetry that fiduciary duties are imposed on company directors.
Well, it's possible, in fact, that the situation of a company could be worse because a beneficiary as an individual might have some knowledge. If the company directors are colluding against the interests of the company as a non-natural person, they have no knowledge.
Indeed, exactly so, my lord. The third point, very briefly, just to finish on the commercial context theme. The other point that's made in my learned friend's written case, and it emerged somewhat in oral submissions. He says it may be mere happenstance whether a commercial relationship gives rise to fiduciary duties or not, to which we would just make a string of extremely short points. The first is, again, that is an irrelevance in this case because the appeal is being conducted on the basis that there were fiduciary duties here. But secondly, as a general point of principle, legal analysis, the question whether fiduciary duties are to be imposed, the legal analysis will always be responsive to the circumstances. Fiduciary duties only arise if the circumstances demand it. It's not happenstance, it's not some accident. It is a matter of legal analysis. And the other point, and in a sense this is made, sorry, can I just take 30 seconds to finish on this?
Yes, certainly.
The other point is that it would plainly be contrary to principle to suggest that someone who is in a position where he owes fiduciary duties to be treated differently because he didn't realise it. The Company Directors Disqualification Act would be writ in water if that were the case. And again, essentially, one can make the same point as I made right at the outset, is that if, which we don't acknowledge, but if there is any risk outside the confines of this case of overreach in relation to the application of fiduciary duties, that can and should be met by a critical analysis of whether the relationship under scrutiny does give rise to such obligations, but that is not a reason for diluting the content of the fiduciary duties in those relationships where those duties are owed. That was all I wanted on that theme. Would that be a convenient moment?
Yes, if that's convenient to you, Mr. Crowe, thank you very much. We'll adjourn then for the day and resume at 10:30 tomorrow morning.